Welcome to the Probate Nation. Whether you are caring for your spouse as a court-appointed conservator or guardian, or with timely executed financial and medical powers of attorney, or just helping out without any of those authorities, your primary goal is to provide your spouse with the best care possible as they age. But paying for that care can present financial challenges. Some spouses restructure their financial obligations to each other through counsel-approved planning. Such planning seeks to preserve more assets for a healthy spouse before undertaking to qualify an ill spouse for adult long-term care Medicaid. Other spouses, in the spirit of self-help, seek to handle that financial restructuring through divorce and then pursue a Medicaid qualification. We encourage the counsel-supervised planning. On the other hand, over the course of 2 shows, we will take a look at how complicated the latter approach, namely divorce, can be, and the unforeseen but practical consequences it causes. We are pleased to have 2 Virginia attorneys who handle matrimonial and elder law matters as our guests this evening. They will serve as our guides as we explore this topic and its wide-ranging implications for spouses who may be traveling on the Virginia Living Probate train. Our first guest is the founder and principal of the Arlington law firm of McCarthy Law, PLLC. Her practice focus is domestic relations, wills, estates, and trusts, as well as elder law. She serves as a certified GAO for children and for incapacitated adults. She is a member of the National Academy of Elder Law Attorneys and the local chapter called Virginia Elder Law Attorneys. Our second guest is of counsel to the Fairfax law firm of Cullum, Sharp, Autry, and Day, where she handles family law matters with elder law issues. She's a member of the Virginia State Bar, Virginia Trial Lawyers Association, Virginia Academy of Elder Law Attorneys, and the Fairfax Bar Association. She has previously presented at continuing litigation education programs for the Virginia CLE, the Fairfax Bar Association, and the Virginia Academy of Elder Law Attorneys. Both of our guests have previously spoken at continuing legal education programs on the topic of where family law and elder law overlap. Please welcome attorneys Courtney McCarthy and Sharon Henderson. Ladies, thank you for coming in today.
Thank you for having us.
Yeah.
It's my pleasure. We're going to have a very, very interesting conversation over the course of 2 shows about how domestic relations law really intersects with the elder law. So I appreciate you guys taking the time to talk about that. So Courtney, let's take a look at it. What are some of the rights and duties that marriage imposes on spouses in Virginia?
Well, there are many of them, but for purposes of our discussion today, some of the most important ones are have to do with making health decisions for your spouse, and also issues of support. And you have a duty to support your spouse. With respect to the health decisions, the Virginia Code talks about if an individual is incapacitated and they don't have a guardian appointed for them, or they don't have advanced medical directive or some sort of other legal document that appoints an agent, that the doctors can look to a spouse to make that decision. And with respect to issues of support, as I said, you have a duty to support your spouse. And what that is in Virginia, they don't quantify exactly what that means, but they say that you have a duty to ensure that your spouse is not left in necessitous circumstances. So it's a duty of a minimum amount of support to ensure that their basic necessities are taken care of, or any emergency medical care is provided for. And you can be responsible for bills related to that from doctors and hospitals that provide services in Virginia.
And that's important. We're going to come back to that particular point later in the show. Now, are these above obligations impacted in any way if a spouses separate or if they divorce?
Yes, they can be. Typically, the separation is not so much of an issue with respect to these, the health care decisions and the support obligation. But when you have the divorce, then that's when it comes into play. As I said, the Virginia Code talks about a doctor can look to a spouse to make medical decisions when there's not already an agent in place.
Okay.
And so that's one of them.
Now, and continuing with that discussion, how is a spouse's health care decision-making authority impacted on separation or divorce?
Well, as I said, separation, there is no impact. You're still for the health care decisions. But when there's a divorce, it terminates on the filing of the divorce.
So that's important to know.
That is important to know. And actually, I guess I should back up and say, it terminates when you file a divorce. It doesn't even have to wait until the divorce is final, but as soon as a doctor knows that you have filed for divorce from your spouse, then the code does not authorize them to look to you to make medical decisions, which makes sense in a lot of circumstances.
And I think that's one thing we're going to see that I would advise our audience to keep in mind is that at different points in time, whether you're getting divorced or you file for divorce, different things happen. They don't all happen at the same time. And so we want to make sure everybody keeps that in mind as you listen to our speakers. Let's talk about the financial power of attorney. How is that impacted by separation or divorce? Why have a financial power of attorney in place?
So a financial power of attorney, it can depend on what it says in the document itself. Many of them don't actually have anything in them indicating something something explicit, like if my spouse is divorcing me, they're out.
Right.
But the Virginia Code does provide that the authority for a spouse to act as an agent under a financial power of attorney does terminate when there's a divorce filed, or some formal separation is filed, or even if there is filing for custody of a child that they might have in common.
Okay.
Then the code does say it terminates.
Okay. Okay, so let's move to support, Sharon. How is the spouse's obligation to provide that support that Courtney was talking about? How is that impacted by separation or divorce?
Well, you do have a duty of support, but that duty of support can be met voluntarily. So you might never go to court if you're voluntarily providing support and your spouse is fine with the amount that you're providing. On the other hand, perhaps your spouse decides that they want to have an agreement that's essentially blessed by a court, so you might have an agreed court order setting spousal support. Then there's a kind where your spouse doesn't agree with the amount that you're paying, and you have to have a court hearing, and then that would be set by the court, and you have two choices in where to get that. You can, if you're not filing for divorce, handle your support action in the Juvenile and Domestic Relations District Court, or you can file for divorce in a circuit court and let the circuit court judge decide that. And this would be while the litigation is pending, between the time you file and the time a divorce decree is entered. There's one set of standards, and then there's another set of standards for determining final support.
Okay. Well, that's interesting, Sharon. Now, when does the actual spouse's support terminate, though?
Well, spousal support that's temporary support while the divorce action is pending ends at the divorce. But permanent spousal support, you would have your choice of three kinds. One is the old-fashioned, modifiable, permanent spousal support that ends when either spouse dies, either former spouse dies, the spouse receiving support remarries, or the spouse receiving support cohabitates with someone in a relationship analogous to marriage for more than a year. Then we have two other kinds of support. A court can award lump sum support, which is one set amount, or they can award time-limited support. And that time-limited support ends according to when the court determines.
Okay. Okay. Now, what effect does a spousal support order have on Medicaid qualification, if any?
Well, generally speaking, when spouses go through what we call a Medicaid divorce, it's because the spouse who's ill and wants to apply for Medicaid has most of the assets or income. So for purposes of Medicaid qualification, Medicaid is not going to deduct any spousal support amount paid to a former spouse. And that means essentially that you're not considering the spousal support. Even if you're paying it, Medicaid's going to treat it as if you're not.
Okay. Okay. Well, let's turn. We talked about support. Let's talk about division of property. So I know it's possible to transfer all types of property in the course of divorce, although there are some things that have to be done very, very specifically, like pension plans pursuant to a quadro. But Courtney, how is property owned by either spouse typically divided up between them in a divorce?
So there's a process that the court goes through. It's called equitable distribution.
Okay.
And in that process, the court needs to decide how they're going to distribute the assets and the debts of the parties. And the legal titling of that asset or debt, meaning how it's titled, if it's a house, if it's only in one spouse's name or the other, doesn't necessarily mean that it's going to remain fully with that spouse.
Okay. Okay. So what is the process to accomplish this thing you call equitable distribution?
So what happens is the parties need to provide the court with a list of what their assets are,
Okay.
what they propose, if they don't agree, what they propose, the values, each of their respective positions on what the value is of that. And then the court needs to take into consideration all the information and evidence it receives. It needs to classify it, deciding whether it's going to be separate property or marital property. They need to determine what the value of it is. And then at that point, they go through a list of factors to see how are we going to divide these assets up between the parties based on circumstances of the marriage.
Okay, so let's talk a little bit about what is accomplished in the classification of assets. Let's just kind of, Sharon, you want to take a look at that?
Well, there's essentially three kinds of assets. There's separate assets, which means the spouse brought it into the marriage, they had it before the marriage, or they received it as an inheritance from someone other than their spouse, or it was a gift from someone other than their spouse. Then there's marital property, which is all property that the parties acquire during the marriage. It could be a house that they purchase with their earnings. It could be any number of assets that are accumulated during the marriage. Then there's property that's hybrid, part separate and part marital. For instance, if the spouses are contributing to an investment account with their earnings, and then one of them gets an inheritance and buys some stock with that inheritance, that would then be hybrid property for the whole investment account.
So what is accomplished in the classification of debt?
The same sort of process has gone through. Was it a debt that one of the parties had before the marriage? Was it a debt accumulated during the marriage for appropriate living expenses? Or if it was accumulated during the marriage for some purpose other than a marital purpose, such as the support of a third party who broke up the marriage, then the court might determine that that was not a marital debt.
Okay. What is accomplished in the valuation of assets and debt? When do we value these things?
Well, as Courtney was discussing, they do that valuation at the time of the final divorce hearing, and then the court looks at all of the factors in our statute, which include things like what contributions did the parties make to acquiring these assets, who took care of them, what was the cause of the breakdown of the marriage, what's the age and the health of the parties. And they go through all those factors, and then the judge determines what should be an equitable distribution amount. And it does not depend on who owns the property, but rather, is it separate or marital?
So it doesn't mean we don't just split things 50-50.
No, it's equitable distribution, it's not equal.
Okay. So
In fact, the code specifically talks about it's not a 50-50 split.
they want to make people
That
clear.
that is not a presumption, and case law does, I should say.
What is accomplished in the distribution of assets and debt? So we work through that process as you just described. It's not 50-50. A court's going to make that decision. If the parties actually can agree among themselves, then of course that provides for a different resolution then.
If the parties can agree among themselves, then they generally enter into an agreement before the divorce, and the court will, so to speak, bless that agreement and make it be part of the final divorce decree. So that is highly encouraged, and it happens in many, many cases. In fact, most cases are settled before a judge has to make a decision.
Probably just as well too.
Yes, saves them the attorney's fees.
Well, let's turn to another component that gets melded into this asset situation. That's called rights of survivorship. So, Courtney, what does right of survivorship mean?
So that means it's a situation where there's an asset that's jointly owned between parties, and if they hold it with right of survivorship, then when the first of the parties passes away, the ownership vests solely in the remaining survivor.
Right.
And so therefore they become the sole survivor. One of the most typical types of property that we see that in is maybe, married people own a house.
Right, of course.
And then they own it as tenants by the entirety, which is a form of owning it as joint with right of survivorship.
Right. So what assets typically, again, apart from other than the marital home, what are the assets that we typically see being held as joint tenants with right of survivorship between spouses?
We see bank accounts,
Sure, of course.
brokerage accounts. As I said, real estate's the most common. And there are some limited pension plans or 401k plans that have an ability to have that right of survivorship, but for the most part, retirement accounts can only be owned by one individual.
Sure, for tax purposes, of
Right.
course. Of course. How does the separation or divorce affect the right of survivorship?
So separation doesn't have any impact because
Okay.
they're still married, they're still jointly owning it with right of survivorship. But divorce will sever that tie.
Okay.
For example, as I said before, a married couple might own a house as tenants by the entirety. And once they become divorced, they now become tenants in common,
Okay.
meaning they both have equal ownership in it, but there is no right of survivorship. So when one passes away, their interest in the property still remains, and it's now part of their estate, and however their estate would distribute it.
Okay. All right, let's switch gears then. So the other thing besides survivorship features is beneficiary designation. Okay, so Sharon, tell me a little bit about what is a beneficiary designation?
Beneficiary designation is anything that's contractual. For example, a life insurance policy is a contract with a life insurance company that they will pay X amount of dollars when you die, and you name a beneficiary. You might also name a beneficiary of your IRA. 401ks frequently have beneficiaries. There are some pension plans in which you can name a beneficiary. Some bank accounts and some investment accounts also have a beneficiary feature. So that is the type of document we're talking about.
And the bank accounts or brokerage accounts, we see these what they call payable on death designations or transfer on death designations. And of course, we have the transfer on death deed now, so which is kind of a new feature.
Yes, and that's kind of quasi beneficiary.
It is.
And quasi survivorship.
Yes, it is a unique feature. Yes. How does separation or divorce affect these death benefits with this beneficiary designation?
Well, under Virginia law, they are revoked at the moment of divorce. However, and this is a big however, certain federal benefits are not revoked. If you have a federal employees group life insurance policy and you fail to go down to the personnel office and make that change, well, your ex-spouse is the beneficiary because you forgot to change it.
Yikes.
So you'd better go and make those changes. And that's one thing we always advise our clients at a divorce is go check all of these things to make sure you've taken care of them.
Sure. Sure, of course.
Same thing with a lot of retirement accounts that are governed by ERISA. There's a lot of case law about that as well, that there have been situations where people have divorced even though they had settlement agreements that said, a spouse is waiving any interest. They never changed that beneficiary designation, and the case law says federal government laws trump Virginia laws.
Isn't that the case? It went to the Supreme Court.
Yes.
One of our local attorneys took it there?
Yes.
Yes, that was
Murata versus Hellman.
Yeah, that was a
There's
very,
actually a couple of them, but yes, that's one of them.
I think, yeah, that's right. Well, let's turn to get some closing comments. We're in the first phase of this discussion about divorce, and we're having this discussion in the context of people trying to figure out how they're going to pay for people's, nursing home care and deal with the challenges of care for an elderly spouse. Can you share some final thoughts and words of advice based on our discussion this evening? Courtney?
Well, first of all, it's very complicated. My first set of advice is don't try and do this on your own. You really need to seek consultation with an attorney who has an expertise in the areas that you're dealing with, because too many people think they understand it, and it's very complicated, and a lot of attorneys don't even understand it. And the other part is if people are cooperating with one another, you're more likely to get the end result you want if you've got a situation where the parties or other family members are involved and not cooperating, it's going to be a lot more difficult to accomplish the ultimate goal.
It's complicated is truly a correct description about this area of the law. Erin, how about yourself? Some final thoughts and words you want to share with our viewers?
Well, I would say that it is always more complicated than it seems. Everyone has a different situation. You might have exactly the same property as your next door neighbor who got a Medicaid divorce, but it might be that they had certain pieces of property that were separate or marital, and your situation is different. Maybe they had an agreement between all family members and everyone was cooperative. But in your case, the assets are different and the calculations of spousal support, retirement division are all different, and it may look like the same thing, but it's not.
And I think I want to draw out for our viewers as we go through this first part of a two-part program. You know, our lawyers here, you know, bring these different disciplines to bear, but you can't look at these disciplines in isolation. You know, so if we talk about how divorce impacts all the different estate planning documents, and we'll come to find out conservatorship positions and guardianship positions as well at different points in the process. And so just to go out and start moving things around in the china shop, you may find that you're going to break a lot of china in the process, and it may not be necessary to do that. So,
Absolutely right.
so all those disciplines we have in front of us, we're going to continue this conversation in another show, but you know, you need to get appropriate advice, probably from a multidisciplinary group of attorneys as you begin to figure out how this all fits together if you truly are trying to qualify for Medicaid.
Yes, and in general, when I do Medicaid divorces, the clients have already consulted with an expert in Medicaid, or I send them to someone else,
Sure.
just to make sure that they've had an opportunity to really examine and focus and explore all of their options before they make a decision that this is what they think is appropriate and best for their situation.
And there's no question, in our previous, we've done a number of previous shows introducing Medicaid planning both in Maryland, DC, and in Virginia. And for our viewers, I encourage you to take a look at those. But there's those rules are all complicated, and there's many ways to solve a problem. There's not just one solution.
Right.
Okay, so you got a lot of tools in your toolbox. Just got to know which one to apply to your set of facts, and that really has to be done by some professionals. Please, I want to thank you both very much for taking the time to come and talk to us today for a couple minutes and share the beginning of what I think is going to be a great show as we go to our second show in the next upcoming session in another week or so. Thank you very much.
Thank you.
Thank you.
You're welcome. You know, without a doubt, paying for the care of an aging spouse can be challenging. But as the needs of an ill spouse make a nursing home admission necessary, families often turn to the government for assistance through adult long-term care Medicaid. Being married can complicate that application. There are many well-tested Medicaid planning options to preserve and protect some or all of the assets of a couple for the healthy spouse. But divorce is considered a bit heavy-handed. And as we have come to learn from the show this evening, it is very complicated to unwind the financials of a marriage of many years. In our next show, part 2 on this topic, we will review some of the legal, personal, and practical consequences that divorce causes for an existing conservatorship or when it is used as a tool in efforts to qualify a spouse for long-term care Medicaid. I encourage you to join us for that program. This brings us to the conclusion of our show tonight. We hope you found it helpful. Replays of this show and all the shows broadcast to date, along with other helpful information, can be viewed on the Probate Nation website. On behalf of the Probate Nation, thank you for visiting with us.